our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, cousin Jimmy's in a lawsuit.
Innovation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, good morning, everybody, and welcome to the show. Today, we're talking about using LLCs to own investment real estate. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, like our channel and subscribe. You can find us on Facebook, X, and YouTube. YouTube is the most natural and easiest place to engage with us. You can find us at the handle @InRem Podcast. That's @InRem Podcast. Go there, like, and subscribe. Helps us out a ton. Also, you can go to Spotify, Apple Podcasts, or any of the other major podcast platforms. You can download an audio version of the podcast. That helps us out a ton. Sometimes that's the easiest way to listen while you're doing work outside on the weekend or whatever the case may be. Go there, leave us a review. We would appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So for my legal update today, I'm kind of piggybacking a little bit of what we talked about last week with Matthew Potter on short sales. And one of the topics that we kind of dived into is how HOAs and HOA liens fit into the short sale approval process. And so I thought I would talk about HOA liens in Arizona and how they work, because I think there's some, confusion and misunderstanding with that. And not only for just people who live in HOAs, but there's also confusion and misunderstanding as to people who serve on HOA boards, as well as who claim to have the ability or do actually try to manage these HOAs. I don't think they fully understand them or appreciate them, or if they do, they purposely, in many times, I noticed they actually, I guess intentionally, then would be violating Arizona law on some of the stuff that they demand as far as their liens go. So I just want to kind of set forth how liens work, HOA liens work in Arizona, and how they're enforced. So the starting point of a lien, an HOA lien in Arizona, is your declaration. We also call them the CC&Rs. It's basically the document that is executed generally by the developer of the community. And they record that before they go and sell any particular lot, or in the case of condos, any particular condominium. They record that, and that basically sets the rules that come into play for the owners within that community. It also establishes the rights of the association or the HOA to collect assessments. And by the recording of the declaration or the CC&Rs, our statutes say that alone creates the lien against the real estate. No other document is needed according to our statutes. And actually, our statutes expressly state that no other document is needed to basically perfect or establish that lien. And so what that means is your assessment, so the amounts that each homeowner has to regularly pay as owners within the community, those assessments give the association a lien right against the real estate for any unpaid amounts. So if you go and you miss your monthly assessment, then the HOA automatically has a lien against your property for that assessment. It does not need to prepare any form of notice of lien or other document and record it. Unfortunately, and our statutes are very specific on that. It says it in the statutes. No other document is required to establish that lien. Unfortunately, we have HOAs, or in particular, their property management companies, who have on staff, legal document preparers, who immediately, when you miss a payment, they go and they record a notice of lien, and then guess what? They then charge the homeowner who missed the payment, say $300 or some amount, in that range, and say, oh, well, we had to record a notice of lien. And so now you're incurring, this charge. Now that money doesn't go to the association. Your board, your association does not have that money put in the operating account. That goes straight to the property management company. And they do this as a moneymaker, despite the fact that our statutes in Arizona say no additional document is required to establish the lien. But of course, these property management companies, some of them out there make, they do take some money off the top or receive a management fee, but where they make a bulk of their money is charging, the homeowner for these different fees and expenses. And so it's just one additional way to make some money as the property management company, despite the statutes don't require it. They just go and voluntarily do it in order to receive the fee. But that declaration creates that lien, and that's the lien that the HOA has against the real estate. And they have basically, if you miss a payment, the HOA has 6 years in which to foreclose on that lien. And the way that they would foreclose on that lien is they would file a lawsuit against the homeowner in the Superior Court for the county in which the property is located. And it would be a lien foreclosure action. And basically they'd be saying, okay, look, court, this homeowner hasn't paid their assessments for this month, and this month. The HOA has a lien against their property as a result of the declaration. And we want you to basically foreclose. And assuming the homeowner doesn't have any defense, the homeowner either needs to pay those past due assessments plus whatever, interest or late charges, attorney's fees, or other amounts that the HOA is entitled to recover under the declaration and pursuant to Arizona law, and basically redeem or reinstate, the amounts that are owed. And if they don't do that, then the HOA can go get a judgment, and that judgment basically tells the sheriff, "Hey, sheriff, you are entitled to sell the property at a sheriff's sale." Once the sheriff sells the property, or pursuant to that judgment, there's a 6-month period generally that kicks in after that, because it's residential property and likely not abandoned. So there's a 6-month period that kicks in where, once again, the homeowner can go and redeem the property by paying the amounts past due, the attorney's fees, late charges, sheriff's fees now, and other amounts that are owed. And then it pulls the property out of foreclosure. And if they don't do that at the end of the 6 months following the sale of the property, then whoever purchased the property at the sale will own it, and the homeowner no longer has an interest in the property. So that's how liens operate. However, I do want to also discuss the certain charges that are not liens against the property. And examples of those are fines or penalties for violations of the declaration, or also called the CC&Rs. What I mean by that is, some CC&Rs will say, oh, you can't leave your trash can out on pickup day past 5 o'clock. And 5:05, the management company comes along and sees the trash can out, and $25 penalty or fine. And so they send that to the homeowner, say, hey, $25. And the homeowner can decide to pay or not pay that amount. If they don't pay that amount, then it basically is a number on their account, a number in a computer system that says, hey, so-and-so left their trash can out past 5 o'clock. It's $25 and it's sitting there. And at some point, we may have them pay it. But the only way to have that homeowner pay it is to actually go and file a lawsuit for the collection of that amount. That $25 is not a lien against the real estate. They cannot claim it as a lien against the real estate. Instead, the HOA can only recover that $25 by filing a collection action against the homeowner and having a judgment entered against the homeowner after the homeowner has an opportunity to answer, to claim, hey, I didn't leave my trash can out past 5 o'clock, to claim that the fee's unreasonable. Hey, it was out there 5 minutes past 5 o'clock. $25 is unreasonable. They have all those defenses available to them. But after that, if the court rules in favor of the association, then the association can record that judgment. That judgment will be a lien against the real estate. Now, a judgment for fines or penalties cannot be foreclosed like a judgment for assessment. So they can't go to the sheriff and be like, hey, notice up a sheriff's sale, sell the property. Instead, it just sits there, and it can accrue interest, but it just sits there against the real estate. So that at some point, if the homeowner goes and sells the real estate, they have to pay that judgment. But if that $25 is never reduced to a judgment and the homeowner then decides, okay, I'm going to sell the real estate, the association cannot go to the title company and say, hey, look, title company, we have a lien against the real estate for that $25. And the only way you can sell this property or allow this sale to close is to pay us $25. Now, that's what Arizona law provides. Unfortunately, property management companies, HOAs, they don't follow that. They will submit a payoff figure to the title company that includes any outstanding and unpaid penalties, even if those penalties haven't been reduced to judgment. That's wrong. That, frankly, is an unlawful, cloud against title to the real estate. They're claiming a wrongful and unlawful lien. And those amounts don't have to be paid at closing in order to close the transaction because they're not liens. Now, let's say you do close and you don't pay those outstanding penalties and fines. At that point, they still are on your account, and the HOA has 6 years from the date that the wrongful conduct occurred to go and file a lawsuit to try to collect those amounts. Whether they do or don't probably depends on how much those fines and penalties add up to. If it's $25, $50, $100, they're probably not going to do anything with it, and they just kind of go away. If it starts getting up into the thousands of dollars, they may consider filing, some type of action to try to reduce those amounts to judgment to be able to collect. But keep in mind that in Arizona, if you go and you sell you're going to sell your home in an association, and you have amounts that the association claims, and that's all it is an allegation or a claim that you owe it. You don't really owe it. You don't owe it until it's reduced to judgment. But a claim or allegation that you owe money for some type of improper or wrongful conduct in violation of the declaration or CC&Rs, you can sell your property and not pay those amounts. You don't have to pay those amounts because they're not liens. But if you have past due assessments, yes, you're going to have to pay them. They are liens against the property. And the other important thing about past due assessments, and we talked about this in short sales, those amounts are actually personal obligations in addition to being liens against the real estate. So they're what we call recourse obligations, which means even if you lost the property in a foreclosure to, say, a lender, or you did a short sale and did a reduced payoff to the HOA, but the HOA didn't release you from liability, they could then come back later. Remember, they have 6 years from the date that for each missed assessment. They could come back later, file a lawsuit, and try to pursue those amounts against you. And I'm guessing if you had penalties and other amounts, fines, they would include those as well. And unfortunately, during the short sale and foreclosure timeframes, I did have a number of clients who let their property go to foreclosure. I unfortunately did not meet with them, did not consult with them. But then later they came to me and said, oh, I have this lawsuit by the HOA. I thought I was done with this property. I thought when it foreclosed, I was out. And unfortunately, the answer was no. Yes, the lender foreclosed. and the HOA, no longer had a lien against the property, but they still had their recourse rights against you personally. And now you're going to have to deal with the lawsuit. So it's very important in my recommendation is anytime you're dealing with distressed real estate, you should always make and pay your assessments and make sure that those are always paid. That way, if something does happen, like a foreclosure or even a short sale, you're not facing any type of action, lawsuit by the HOA, because frankly, you just want to be done with the real estate, done with the property, done with the distressed property. You don't want to have to worry about a lawsuit, a year or two later by the HOA. So to summarize, the HOA has a lien against your property for unpaid assessments as a result of the declaration that was originally recorded against the community where your property is located. And second, fines and penalties for alleged violations of the declaration or CC&Rs are not liens against the real estate and can only become liens if those amounts are then reduced to a judgment, which is then recorded.
All right. Thank you, Sean, for the legal update. With that, a couple announcements. It's Tuesday. Make sure that you're available at 2 p.m. Arizona time for the Creative Finance Collective. That's every Tuesday afternoon. And we're live on YouTube, X, and Facebook. Go to our channel. Get there. What do we do in the Creative Finance Collective? It's a grouping, a membership of basically lawyers, professionals in the space of creative finance, and we're there to talk about creative finance. But we're also there to answer your questions. And we're on as long as we receive questions. So if you have questions about creative finance, maybe it's just the basics. Maybe it's, I've just heard about creative finance. This is something I'm interested in. What does this look like? Or maybe it's a complex deal that you've seen, an example you've seen gone right or gone wrong, and you want to hear lawyers' take on that from the perspective of different states and jurisdictions. So make sure to join us 2 p.m. every Tuesday, 2 p.m. Arizona time. And again, you can find us for that on YouTube, Facebook, and X. Also, if you have any questions today, make sure to post them in the chat. Sean and I will take questions as we get those. So post those. We're monitoring the chat, and we'll get to those. So today, Sean and I are talking about LLCs, specifically LLCs to own investment real estate. Now, this might sound simple, or maybe you're new to real estate investing, and maybe this sounds complex, but we're going to talk kind of about the A, B, and C's of owning real estate, why you ought to consider an LLC, what the different options look like from start to finish. So we're going to kind of start at the ground floor on this kind of thing. But Sean, one question I think that often gets left undiscussed is why even bother with an entity? Do you even need an entity to go into business? Or I would suggest that the history of the law is that you don't, right? I mean, you could just go into business and you don't need an entity. What does that look like? What would that even be called if you forgot an entity to begin with?
So if you go into business without an entity, you are either doing it as a sole proprietor, meaning it's just you that is the business, and maybe you have, like Sean St. Clair, doing business as this particular restaurant or this type of retail store, etc. That would be example of a sole proprietorship where I actually personally own everything. Or through a partnership, you and I decide, okay, let's go into business together. And the business is, you and I doing business as, and we, select whatever name we're going to do business as. And then we work in the form of a partnership and have an arrangement between the two of us as to the share of profits and losses and that type of thing.
Yeah, and I think what's missed oftentimes is people don't realize people might, for purposes of the law, be engaged in business and not even know it. This goes back to kind of early law school days. But I as I recall, the definition was if you were engaged in an endeavor for profit, you were in a business. That was all that it took, whether that's selling lemonade at a lemonade stand or whether that was something much more sophisticated. You are in business. There is no formation necessary. You can be engaged in the conduct of business for purposes of the law and for purposes of the IRS in terms of taxation, so on and so forth. So I guess it begs the question, because there are partnerships and there are sole proprietorships even happening today as we speak. So if it's that easy, why even bother with an entity? Now we'll get into the different types of entity, but for purposes of this discussion, why do we even bother with an entity, Sean?
So let me jump back and comment on what you were saying, and then I'll answer the question. You were saying, that a lot of people are out there kind of unknowingly, unwittingly going into business as sole proprietorship partnerships. And that's true. And where I see it most commonly is with real estate. A common scenario is I own my home, and I decide that I want to buy another home and I want to live somewhere else. And so I go and I buy another home. Well, the home that I moved out of, I mean, a lot of homeowners do this. They move out of it and they realize, oh, you know what? I have one of those good interest rates, in place, nice low interest rate. Rents are decent. I can rent this and put some money in my pocket every month, pay the mortgage, put some money in my pocket. And so they simply find a tenant, put the tenant in. Well, the house is still in their personal name. So now they're basically running a business because, like you said, it's a for-profit endeavor, right? You're trying to make money off of this property. You're not only paying your mortgage, but putting a little bit in your pocket. That's profit. And yet the property's still in your personal name. And so you unwittingly or unknowingly have gone into business as a sole proprietor or, a partnership. Maybe you and someone else own it or you and your spouse own it. So why form or do business in an entity? And the biggest reason for that is what we call the veil of protection, or the corporate veil of protection, which is basically creating the liability separation between your business affairs and assets and your personal affairs and assets. And that veil of protection creates that separation so that if you breach a contract, you engage in negligence on the, or could be liable for negligence on the business side, whoever's, injured or damaged, they can't go and pursue you on your personal side because there's a veil of protection that separates the two. And likewise, if something happens on the personal side, whoever's, injured or damaged on the personal side can't then go after your business assets because, once again, there's that veil of protection that kicks in. So that's really, and there are other logistical things that come with that, but really the biggest reason is creating that veil of protection.
Yeah. So as you consider the issue of veil of protection, and you can almost track this with the history of the corporate veil and how the law has structured ways to create that veil, that leads us kind of into the conversation of what kind of entity works, because there's not just type of one entity. In fact, I think the very first iteration, I might have this wrong, but I think the first iteration of a way to veil owners from liability was the limited partnership. A different take on the general partnership, which then eventually, the law began to recognize a separate corporate existence through the corporation and so on and so forth. But let's talk about the different types of entities that one might end up considering for business, specifically in real estate. What do you think really the main ones are that investors ought to be thinking about, Sean?
Yeah, so the main four are, the first one, like you mentioned, is your limited partnership. That's basically where you have general partners and limited partners. Your limited partners are only investing capital. They're not operating the partnership. They're not responsible for the operations of the partnership. And because of that, they don't have liability for the debts and obligations of the partnership. They're limited partners, which comes with that limited liability, or no liability for the debts and obligations of the partnership. But then you also have general partners who operate the limited partnership, and those general partners generally can be liable for the debts and obligations of the partnership. But that, like you said, is an early iteration of liability protection in the corporate veil, is the idea of these limited partnerships. Early on, they didn't have to be registered. Now there's a registration process, and they're more formalized than early on, when it was more of a done by agreement of the parties. The next, and this is an old entity as well, an older type of entity, is your corporation. And so this is where you have owners who hold stock who aren't going to be liable for the debts and obligations of the corporation. You have officers, directors who also are engaging in conduct that's not going to be generally liable for the debts and obligations of the corporation. So a corporation took kind of the liability protection that we saw in limited partnerships, but took it even further, which is the corporation stands on its own, separate and apart from its officers, directors, and shareholders. And so, that was kind of an early, corporations have been around for hundreds of years. The next thing that we have are your irrevocable trusts. So there are certain types of trusts that are standalone. Generally, they're irrevocable trusts that provide a certain level of protection. And an irrevocable trust, like a corporation, would also, stand on its own. It has its own EIN, its own bank account, and it does provide a certain level of protection. And then finally, and probably the newest of all of these, I believe, is your limited liability company. In fact, when I was in law school, not every state at that point had adopted or allowed limited liability companies. Arizona had, but there were still some states in the United States that hadn't, they were still operating through corporations. Now I think pretty much every state, allows for limited liability companies, but these are companies. They're not corporations that are basically able to, have the corporate veil of protection and to operate. But it's different from a corporation in that instead of owning stock, you hold a membership interest, which, I own, say, a 5% interest and somebody owns a 95% or 50-50, but, they all add up to 100%. And so you own a membership interest that's documented somewhere, either in an operating agreement or with the state where you formed. And it's not as formalistic as a corporation. Let's just put it that way.
Well, yeah. So
it tends to be more flexible, but it provides a corporate veil of protection.
Yes. And so when you see the corporation compared to the general partnership, for instance, you might wonder, well, why the limited liability company? What was the law trying to do? You might think that the law achieved what it wanted to do with the corporation, and in a lot of respects, it did. But they're pretty stark differences between. Let's forget about the LLC for a minute. Between the general partnership and the corporation. When we think corporation, and it really is the case, you mentioned this, you're dealing with a board of directors, you're dealing with corporate officers. Mm-hmm. We haven't even talked about taxation, but corporations are taxed differently than a general partnership. It is a highly structured vehicles. And then you compare that to the general partnership and you're like, well, what are the rules to that? I just go run and do business, right? I just tell people what to do. I hire folks.
Right.
It's kind of freewheeling. It has a different tax structure. So there's kind of a stark difference in rigidity and flexibility between the two. But there's also a stark difference in liability protection. So a lot of folks would say that the liability company came around really in a sense to be a blend between the two, because I think a lot of small businesses found they love the liability protection, but the corporate governance structure was pretty onerous for a mom and pop business. Why don't you kind of talk through some of the flexibility that an LLC provides as compared to the other two?
Yeah. Yes, that's exactly right. The LLC is kind of somewhere between your limited partnership or your general partnership and your corporation. Basically, the LLC is created through state action. So there's some, in Arizona, we call it the Arizona Corporation Commission. In some states, they use the Secretary of State. In other states, they use the Department of Financial Institutions. There's all kind, each state has their own agency that's going to accept and approve the application, or what we call articles for LLCs. And but they're somewhere in between corporations and partnerships. And the LLC only has two real actors, if you will. So the first is your members, and those are the people that own it. And then if you so choose, you can have managers, which are people that operate it. So unlike a corporation, like you said, the mom and pop, unlike a corporation where you have officers who are like your secretary and treasurer and president, and then you have your board of directors, that you have a chairman and, other, roles there. And then you have your shareholders who actually own the corporation. In LLCs, you have your members and potentially some managers, and it's as simple as that. The reporting generally that you have to do for LLCs is less than a corporation. So normally, at least here in Arizona, the articles of incorporation that you file are pretty onerous. There's a lot of information. There's certain attestations that have to be made by the directors and officers. You have to do an annual report. You have to pay a fee to do that annual report. Versus for an LLC, at least here in Arizona, you basically file it one time and you don't have to give tons of information about your members and managers, some, but not tons. And once it's filed, it's done. You don't have anything further to do. The other advantage of an LLC over a corporation is how the taxes, or how it's taxed. So basically, there are certain tax advantages potentially to operating as a partnership. And especially when it comes to real estate and restructuring of real estate. If you own things as a partnership, you can kind of move real estate around without having to pay capital gains if you ever need to restructure. LLCs can be taxed as a sole proprietorship, as a partnership, but they can also be taxed as a corporation. So if you're operating a professional services business, like a law firm or a doctor's office, or even a real estate brokerage, you can choose what we call S Corp taxation, which gives you the benefits of corporate taxation. And S Corp, this isn't about taxes, but an S Corp is a little different than a C Corp, because the S Corp is kind of a flow through taxation. But you can also be taxed as a C Corp as an LLC as well, if that's what you choose to do. So basically you have this tremendous tax flexibility that you don't have with either a corporation or a general partnership. But at the same time, you get the benefits of a corporation because you get that, full veil of protection.
Yeah, and I think what else goes undiscussed with the limited liability company is it actually provides you with lots of choices. Now, in our discussion, we've kind of assumed maybe the structure that you would take with a limited liability company. But the neat thing about the LLC is you can choose if you wanted it to look like a corporation in some respects in management structure, because maybe your business is starting out a little bit different than just a mom and pop, you can do that. If you like a certain taxation structure, it used to be, I won't go into all the details, but it used to be that, boy, you almost never elected to be taxed as a corporation, double taxation. But in a recent federal tax change, there was some interesting benefits to being taxed as a corporation for the first time. We'll see what that looks like going forward. But to just straight up have the option to basically pick and choose what's going to fit best for your business is what makes the limited liability company really a nice option, whichever way that you go, while still giving you the liability protection. So if we're forming an LLC, we're used to hearing the term bylaws for corporation and documents that are going to govern our relationship as owners of the LLC. How do we do that in the context of an LLC? And if we don't do that, or if we forget to do any sort of document, are we just SOL, out of luck, or are we governed?
Well, it depends on what state you're in. So in Arizona, when you file your articles of organization, that's what you use to create an LLC. You're going to tell our Corporation Commission a few things. So the first thing that you're going to say is, here are the members of the LLC. And then if you choose to be managed by managers, you're also going to say, here are the members and here are the managers of the LLC. And you're going to list their names and some contact information for them so that our state has a record of who owns. So members own the LLC, who owns the LLC, and who manages the LLC. If you choose not to elect to have managers and you just say, Arizona, here are the members, in that case, you're going to be considered a member managed LLC, which means the members not only own it, but they run it. And so our state has a public database on the Arizona Corporation Commission where anyone can go on and look and see, here's who owns this LLC, here's who manages this LLC. And because of that, our state says that alone is enough. And you have a validly formed and operating LLC because you've provided or filed your articles of organization and you've identified your members and managers. And from there, our statutes govern the operations of the LLC. And you don't need to do anything else. So, if you're a mom and pop company and you're like, hey, it's just me and my spouse, or maybe just me and a partner, 50-50, and you go and you file your articles of organization, you could take those articles, open a bank account, you can start operating, and you're good to go. There's really not much more to it. However, instead of bylaws or a shareholder agreement, in Arizona or anywhere in any state, there is a document called an operating agreement. And that is, in Arizona, like I said, an optional document for the purposes of validity of the LLC. But that's a document that basically is going to be like your bylaws in that it's going to state how, meetings are held, who can, what the number of votes you need to pass anything, how many people need to be at a meeting for to create a quorum. It's going to provide a lot of information as to the operations of the LLC. It also is going to define ownership of the LLC and say who owns what in the LLC. It's also going to say who manages the LLC if it's a manager managed LLC. That document, once again, is not needed in Arizona, but it is under certain circumstances highly, highly recommended. And in particular, it's recommended if, generally, I would recommend it if it's not just a mom and pop. If two partners are going to go into business together and form an LLC, that way there's an understanding of how things are going to operate. But it's particularly important if you have more than just two people who are 50-50, and you're going to have different percentages of ownership. Let's say that, Andy, you and I are going to go into business with a third party, and you're going to own 40%, and I'm going to own 40%, and that third party is going to own 20%. Well, we need to define that in an operating agreement, because otherwise, when you file with the Corporation Commission and list all three of us as being members, the default or the presumption is that we all own 1/3. Well, that's not what we've agreed to, right? Because you and I will each have 40%, and then that third person will have 20%. And so an operating agreement is critical in that situation. Now outside of Arizona, it depends on your state and what your state statutes state, but a lot of our clients, investor clients, want anonymity. And the way to obtain one of the ways to obtain anonymity is to go form your LLC in Wyoming or Delaware. And when you form an LLC in one of those states, you are recording your articles of organization, but they don't provide the same information that is provided in Arizona. In that case, your articles of organization basically state the name of the LLC and the statutory agent, which is not a member or manager, but simply a company who is authorized to receive, service of documents, service of lawsuits, or service, what we call service of process in the legal world. And they then receive those documents and then pass them on to the actual members or managers. But the state of Wyoming and the state of Delaware has no record anywhere of who actually owns the LLC. And because of that, those states say that an operating agreement needs to be executed to validly operate an LLC under those states' laws, which makes sense, because somewhere you have to define where the buck stops, right? Who can actually make decisions, who can act on behalf of the LLC. And if you don't have a signed operating agreement, all you have is a person purporting to claim to have some authority to act on behalf of an LLC, but no actual legal authority, because there's no legal document giving them that authority. And so, it's critical that in those states you have an operating agreement. And unfortunately, I've seen scenarios where, for whatever reason, I'm involved. Our firm did not form the LLC, because had we formed it, we actually require a signed operating agreement before we actually file the articles with those states. But I've seen, other non-attorneys who have formed these, and they form them, and then they send the client a Word document of an operating agreement with some rather vague or unclear instructions as to what to do with that Word document. And so, then I get involved for one reason or the other. Maybe it's restructuring, maybe it's putting agreements together. And I say, hey, I need to figure out who can, sign on behalf of this LLC, this Wyoming or Delaware LLC. Send me that, your operating agreement. And unfortunately, I'm sent the email with the Word document. Hey, here's our operating agreement. Like, well, no, I need the signed operating agreement. Oh, we don't, this is all we have. You mean you've been operating the last 2 years without a signed operating agreement? It's problematic. So in Wyoming and Delaware, you need an operating agreement. In Arizona, you can get away without one, but it's recommended in certain circumstances, highly recommended in certain circumstances.
So prior to this year, the federal government had very little to say, if really anything to say, about the formation of your company. They didn't have anything to say. It was a state by state issue and you just illustrated the differences in some of the states in forming your company, what they're going to require, so on and so forth. It's a state's issue. It still remains a state's issue, but the federal government passed a law, and that law went into effect and really started to impact businesses, new and old businesses, beginning this year, and that's called the Corporate Transparency Act. We've devoted an entire show to that. But Sean, break down for us at least what the investor forming or with a current company needs to be aware of currently in 2024 with respect to the Corporate Transparency Act.
Yeah. So there are some exceptions, and I don't recall off the top of my head exactly what all of them are. But there are certain entities that can be deemed, inactive that don't require this, but you're going to want to definitely figure out what those exceptions are. But basically what the law provides is anything formed after 2024 must submit certain information to the federal government through or to FinCEN and the FinCEN website. And it's like Financial Crimes Reporting, network or something like that. But it's an agency or department within the federal government that's going to collect all this information and it's basically beneficial owner information. So if you formed your LLC in 2024, you have like 60 days to go and submit this information to FinCEN. And it's basically the beneficial ownership information. So I talked about where does the buck stop? That's what you're doing in this case. You're submitting, every, owner and then, if say the owner's a trust, then you got to go and say, well, who created the trust and who the beneficiaries of the trust? And you basically work your way up. If you have multiple entities that own it, you have to keep going until finally you get to a person who's behind or persons behind the enterprise, or behind the LLC. And you have to list all of that and provide, addresses and, some pretty comprehensive information. I think even some social security numbers and things like that to the federal government and provide all of this. And if you don't, the penalties are pretty severe for not complying. So that's for anything from 2024 on. Anything formed before 2024, you have to report that information before the end of this year. So before December 31 of 2024, or actually before January 1 of 2025. So you can't do it on January 1. You have to do it December 31 or before then. And basically you have to provide all that beneficial ownership information. Now, going forward, if you amend your LLC, change the address of your LLC, or basically make any significant change to your LLC, you have to then report this information again to FinCEN and update them with the updated, beneficial ownership information. So you have to basically do all of this federal reporting, and the timeframes are even going to reduce to, I think, 30 days come 2025 for any changes, any new LLCs. You're going to have to get all this information reported. So it's not something to be taken lightly. Honestly, at this point, we're in September. We're getting towards the last quarter of the year. Now's the time to think about doing this. We not only devoted a whole show to this, but we also devoted a whole show to the constitutional challenges to this. And unfortunately, the ruling by the court in Alabama, the federal court in Alabama, only applied to those plaintiffs. They did not do a nationwide injunction as to this law. We did talk about it with Drew Jenkins regarding kind of, where we think this is going to go. And I think there were a lot of, strong challenges to the law. And getting back to what you said, one of the biggest issues is this is a creature of state. This arises out of state laws. And if you don't have a state law, you don't have an LLC. Some states, in fact, like I said, when I was in law school, didn't have LLCs. It wasn't even a thing. Well, now we have these state, most states allow them, but they're created by state statute. And so if you think about it, and frankly, I have this, and so I'm going to have to, do some reporting at the end of the year. But in Arizona, when you form an LLC, you can form it and forget it. You don't have to do regular updates. You don't have to do anything. So I always generally have LLCs that I form that I don't get EINs for, I don't do anything with or whatever, but I have them in case I want to generally invest in real estate and I don't have to run around while I'm trying to close on real estate and, form an LLC. It's just there. I just have to now get an EIN for it, open a bank account for it. It's completely, at that point, a state law creation. It has nothing to do with the feds. It doesn't even have a tax identification number. Doesn't have a bank account. Has nothing to do with the feds. It's simply a creature of state law. And now the feds say, oh, well, I have to report that, which I think is the biggest issue with the federal law. We'll see what happens, but it's still in effect. It still has to be complied with. So you have to comply by the end of the year.
All right. So we've laid the groundwork for the limited liability company or having an entity structure of some kind at a minimum for liability protection. But let's talk about what we think are some of the benefits and disadvantages of holding investment real estate in a limited liability company. We'll start with the advantages. And let's just go through them, Sean. But first big one is asset protection. How do you see that as a big advantage for the LLC and investment property?
So asset protection is probably your biggest advantage, right? So it creates that separation between your personal and your business assets. So if you have, let's say you have multiple rental properties and you own them in separate LLCs and say, somebody comes onto that property and they somehow manage to electrocute themselves. And now they say, well, you as the homeowner are to blame because you had faulty wiring or something else, right? And now they're going to, have a lawsuit against you. Well, if you have that in a separate LLC, that lawsuit is only against that LLC and can only involve that property. But if you have that in your personal name, then that lawsuit's against you personally and involves all of your personal assets. And you haven't, limited it to just that property. Or let's say that you have multiple properties in that one LLC. Well, now those multiple properties are exposed for the accident that occurred on just one piece of real estate. So you're basically by creating LLCs and owning real estate in LLCs, you're basically kind of able to siphon off that one LLC, that one piece of real estate, and that is the only asset that's available for any type of recovery. Once again, no matter what you do with LLCs, whatever, we've talked about this, I've given legal updates on this. Nothing that we can do as attorneys, nothing that LLCs can do is any better than the actual insurance coverage that you can obtain and, make sure that you're properly covered, fully insured, based upon your assets and, business endeavors. And so insurance is still the best, but the next thing you can do is to have an LLC and have LLCs generally own each, piece of real estate you have. There's some exceptions to that rule. And I talk to my clients about those, but regardless, asset protection is the biggest, in my view, biggest advantage.
So Sean and I aren't CPAs or tax attorneys, but you are granted advantages or at least choices when it comes to how you elect to be taxed. And taxation and how you're going to choose and elect to be taxed, well, is largely going to depend on the type of your business, the assets that your business are going to have. And that's why it's important to engage a CPA. But Sean, are there particular tax advantages that you like that particularly apply when real estate is involved? Because that's what we're talking about, really, in investment real estate being owned by an LLC.
Yeah. So the biggest advantage is, and I talked about this a little bit earlier, is you still receive the same corporate veil of protection as a corporation, but you can choose to tax your LLC and thus your real estate ownership either as a sole proprietorship or as a partnership. And the significance of that is you can restructure your real estate assets without having to pay capital gains tax, as long as, you know, ownerships and things like that are the same. So let's say, for example, I ended up having 5 pieces of property in one LLC. And I'm like, somebody, you know, I'm like, oh, that doesn't make sense. Like, I'm exposing those 5 pieces of real estate. Well, I can go, and let's say I'm the only member of the LLC. I can go form 4 other LLCs with me as just the member. And I can, if my LLC is taxed as a sole proprietorship, or if I have another member as a partnership, I can move those properties from that one LLC into each of those LLCs without any, you know, tax consequence, no capital gains. But if I were to hold them into a corporation or an LLC that was taxed as a corporation, and then I tried to restructure that way, I would actually have to pay capital gains tax on those transfers. And so, you know, that would be a major problem, and basically stops you from being able to do any type of restructuring with respect to your assets.
You know, another benefit that I like with regard to having an entity owned, specifically an LLC owned real estate, is the ability to have another method of disposing of the asset. And by that, I mean, you know, if you're individually in the real estate, there's only one way to dispose of that real estate, and that's to sell the real estate and transfer your name on the deed. But if an LLC owns it, certainly the LLC could sell the property and change the name on the deed, but you can also keep the LLC on the deed, right? And just sell your ownership interest. Have you done that or seen that done? I'm sure you have.
Yeah. Yes, that can be done. I've seen either partial ownerships being sold or, you know, full ownerships being sold that way. And so that is, you know, it gives you some flexibility to be able to do that. Obviously, there's certain due diligence and things like that that have to be done from if you're going to buy that way. But yes, that does give you much more flexibility. So instead of selling the actual real estate, you just sell some or all of the ownership interest in the LLC that owns the real estate, which has basically the same effect.
So while we're on it, we want to be honest, and we want to give the disadvantages as well, or things to watch out for with LLCs. In my mind, the biggest one is the issue that you have to manage the company. In order to keep a legitimate limited liability company, you have to treat it like a legitimate business. Now that doesn't sound, this is not a concept that sounds very difficult in a discussion or in theory, but in practice, I think Sean and I have probably run into plenty of clients where in practice this is difficult. Where have you seen this go wrong, Sean?
Yeah, where this goes wrong is when let's take a step back. We've said this before on the show. The greatest level of asset protection requires the greatest level of work. And so where this goes wrong is that somebody basically doesn't want to do the work because of the maintenance involved, and they stack, you know, 10 properties in one LLC, and then they end up with some type of lawsuit as to one of those properties. And hey, guess what? You can't start moving things out now. You're stuck, and all of those properties, you know, potentially are on the hook. So somebody gets a judgment against the LLC, they record it against the LLC, and whatever property that LLC owns, and if it's 10 of them, that judgment's a lien against all 10 of those properties because that's what the LLC owns. And you and I both know, like, once you become aware of a claim, like, there's no moving it out. I mean, that's a fraudulent transfer that you can't do it. So you're stuck. And so that's where I've seen it go wrong. I've also seen issues where claims are made to pierce the corporate veil on the basis of, and the main one is commingling of funds. Basically, the LLC was LLC in name only, because you do not need to have an EIN or a bank account to put property into an LLC. That's not required. So I could go and form an LLC with the Arizona Corporation Commission, and I could move my personal real estate from my name into the LLC. And I don't have to do anything else. And I could enter into a lease agreement with the LLC and the tenant. And I could tell the tenant what, bank to, put the money into. And it could be my personal checking account. And the money comes into my personal checking account. And unfortunately, we've seen these types of things happen where it's an LLC in name only, but when you pull the curtain back, it's really just the individual operating their own business, as almost as a DBA in the name of the LLC.
Right.
And right there, I mean, you're going to be able to pierce the corporate veil. It's a major problem. And so, the lack of maintaining those corporate formalities, taking the money out of the LLC directly, not as a distribution to you and then using the money, but directly from the LLC to pay your personal credit card bills and your, the rent on your personal residence, or mortgage on your personal residence, your personal car payments, all of those things create problems. Once again, this isn't a tax thing. You can talk to your CPA about how you should, maximize taxes and what you can pay or can't pay. But at the end of the day, to keep the corporate formalities, you have to use business funds for that particular business and that particular business purpose only, and then use personal funds for your personal affairs. And otherwise, I've seen lawsuits to try to pierce the corporate veil when those formalities aren't kept or maintained.
Yep. Do the work and good things happen. All right. With that, everybody, that is our show. If you have any questions, make sure to join us at 2 p.m. today, Arizona time, for the Creative Finance Collective. We're going to get deep into creative finance. Looking forward to having you and participate in questions. And we'll plan on seeing you next week for next week's show. Thank you.
Have a good day, everyone.